Welcome to StarTalks powered by AdvoTalks. Today, we have the privilege of hosting Advocate Saransh Chaturvedi, an accomplished legal professional who is a legal expert in corporate and intellectual property law. After having an academic journey at the prestigious institutes of law, Mr. Saransh is culminating in a comprehensive expertise in corporate and intellectual property law. After the Bachelor of Laws from the BHU, he has pursued an LLM, that is the Masters of Law, from Rajiv Gandhi School of Intellectual Property Law, part of the prestigious Indian Institute of Technology, Kharagpur. His professional focus revolves around the intricate domains of corporate law and intellectual property, with a specific emphasis on IP strategy in corporate management. With an innate passion for the convergence of law and business, he has honed his skills to cater to the diverse needs of the clients navigating the complex landscape of intellectual property rights within the corporate environments. Drawing from his expertise, Advocate Saransh Chaturvedi specializes in various facets of intellectual property, including patents, trademarks, copyright, and designs. He brings a nuanced understanding on legal frameworks, strategic foresight, and a commitment to delivering tailored solutions to effectively safeguard and leverage intellectual assets in today's dynamic business landscape. Today, he has joined us at StarTalks to express his views on artificial intelligence and the intellectual property and associated legal framework. I should admit that I am quite excited to host Mr. Saransh Chaturvedi. With that, I warmly welcome Mr. Saransh Chaturvedi to our talk show, StarTalks powered by AdvoTalks. Welcome to the show, Mr. Saransh.
Thank you so much, Siraj, for calling me to this esteemed platform. And I'm really glad to be here. More glad to be here because of the topic, because I still remember the days when I started my journey. This topic of artificial intelligence and intellectual property is already a new topic, but that time it was also a new topic. Nobody knows about it. And I found it very difficult to understand and to get through the nuances of this topic. So I feel that this conversation will definitely help the budding students as well as the lawyer dealing in this, so as to get the basic understanding of what artificial intelligence and intellectual property can be. Yeah.
Great, sir. We are looking forward and we are quite excited at AdvoTalks to have this
Thank you so much.
elaborated discussion. So let me start with the key intersections between understanding these two areas that we are going to have a detailed discussion about, which is around the artificial intelligence and the intellectual property, right? So please let us kind of, try to understand what are the key intersections between the artificial intelligence, the AI, and the intellectual property law.
All right. So, Siraji, before getting exactly into the core understanding of what AI and IP can be and what is actually all about, I would just like to go beyond that. I feel that we all are student of law, and nobody is an expert. Even the great legal luminaries have always been stated that they are all student of law and not an expert. So this artificial intelligence and intellectual property, the example of this intersection makes us very clear that we all are just a student of law and not an expert. Why and how? It's because whosoever claimed to be an expert on this law, when artificial intelligence came up, they were stunned and they were not able to understand as to what and how we have to go forward. So ultimately, those legal luminaries again have to open up the book and understand what actually can be done. So it gives us an impression that we all are just a student of law, first. Secondly, when we try to deal with law per se, we always found that law is always a manifestation of the society. And how the society will go ahead, the law is the reflection of that society, right? But in the coming decade, in the last decade, if I may correctly say so, I know that the artificial intelligence was beyond that as well. But in the last decade, where the development was tremendous, the influx of artificial intelligence in the society was so tremendous and so fast that the law was unable to digest that influx. That was the point is, because we say that we were not even expecting that, right? So the legal regime, the legal paradigm was not even expecting the influx of artificial intelligence in such a tremendous manner. And the all issues, the all debates that we are trying to focus, and not only we, but the world as a whole is trying to focus, is because of that indigestion by law, right? So when we try to deal with the intersection of artificial intelligence and intellectual property, first of all, we have to make us very clear that the indigestion of law with the influx of artificial intelligence is still there in the society. Now, I said law, not IP. But if we try to deal law per se, the intellectual property part of the law is the most affected part when it comes to the influx of artificial intelligence in the society. So why I am saying so, because I want to connect to the audience how the story begins, right? And how the story will unfold later on. So the law was not expecting that. And in law, the artificial intelligence, the connection between the artificial intelligence and the law per se, I'm saying law per se, has been the most affected. And in law, intellectual property is the one which is most connected as well as most related to artificial intelligence. So the relationship between AI and IP is just like a relationship between, I can say with an example, between two people who had a recent breakup. How and why? When you had a recent breakup, you are hating that person, but you are also having a soft corner. That is what the intersection of artificial intelligence and intellectual property is, and I will explain this issue of hating, and as well as the what do you say, so the soft corner part later on when we unfold this all interview.
Right, Saran sir, like that's a great unveiling from you about how the relation between the artificial intelligence and intellectual property has evolved over a period of time, and you have rightly kind of introduced the kind of lack of speed to kind of adopt to the changes that have come in the artificial intelligence from the legal fraternities. Like that is the need, and you have also kind of brought this up. The AI is the most affected part probably. I mean, like the intellectual property law is the most affected part, or probably the most I should probably call it out as the easy picker when it comes to the artificial intelligence matters, right? So let's delve deeper into this discussion. This is quite exciting, Saransh. Let me commit that. How do you see that the AI can challenge the traditional notions of the IP protection, particularly in the areas of the patents and copyrights and the trademarks?
So, Siraji, this will be a long answer, and please excuse me for that. So, see, as I told you, that artificial intelligence influx was tremendous. Now, as a person who is seeing the world, let's say, for example, we are sitting in a mountain and we are seeing the world. We are seeing artificial intelligence coming so fast, and the law is not able to digest that. What will happen? The influx of artificial intelligence has created a void. It means that, fine, okay, our AI has come up, but law is not able to digest it. There are some expectation from artificial intelligence, but the expectations has not been fulfilled by the law. This can be a strong quote which can be made early if we write a research paper, that the expectation of artificial intelligence has not been fulfilled when it comes to the part of law. And preferably, when I say law, it is intellectual property only, because ultimately we are dealing in this intellectual property framework, primarily in intellectual property framework. But yeah, the law in totality, since we will also be dealing in different parts, like let's say, for example, data privacy, data management and all. So law per se, the expectation from law per se has also not been fulfilled, leave alone intellectual property, right? Now, coming to specifically to intellectual property, how artificial intelligence is working and how artificial intelligence is not working, or rather it is also creating hindrance. And here I will substantiate my word of saying the heartbreak one and the soft corner one. So the soft corner, let's talk about the soft corner. The artificial intelligence is creating tremendous amount of intellectual property. It's helping the creation of intellectual property in a tremendous manner. First. Second, the artificial intelligence not only is helping in intellectual property creation, but it's also helping in IP management part. Third, the intellectual property commercialization part, which is already a big debatable part, is also being done by the artificial intelligence. So the AI models today all the big companies, big corporates are using the AI models to substantiate their IP creation, to substantiate their IP management, to substantiate their IP commercialization. But on the other side, when we talk about the heartbreak part, or rather we are talk about the hating part, in all these three mandates, artificial intelligence is creating hindrance as well. You are creating intellectual property through the AI models, the AI algorithms, which we will discuss earlier, later on in the interview. We are also creating IP management part. The IP management, the IP asset management is dealt with artificial intelligence. But the IP infringement part, the AI models, the AI tools which are being used by the big corporates are getting along, are the major cause for IP infringement part today in today's parlance. So at the first stage, you are using artificial intelligence for your benefit. But on the second stage, you are using, or the artificial intelligence models are being used for hindrances, for obstructions, and for infringement as well. So here the void is, you can use artificial intelligence for betterment of the society, but the usage of artificial intelligence can also be done for the hindrance of society, or for the hindrance of intellectual property regime, right? So when this question comes up, the traditional notion of IP protection, as I say so, the traditionally what we find, the you are having an invention, you will go to the IP India office, you will file for the invention, and you will get the patent. Fine, fair enough, it's done. Now this issue of artificial intelligence and influx has devastated so much that you yourself, as a part of intellectual property owner, is not able to understand where the infringement is happening. If I'm not clear, you can just ask me, or
No,
rather
no,
you can
it's
just
a right,
cross
right. I
question.
should admit that it's a quite interesting narration that you are giving right now. Like you have started comparing with a recent breakup and how a soft corner as well as a heartbreak kind of a emotions are having between these two parties. In a similar fashion, you're quite awesomely explaining the relationship between the intellectual property. Where did it all start when the artificial intelligence has come into picture? And also there are multiple aspects that you have mentioned how it has uplifted the IP in the aspect of the IP management as well as IP creation itself. The artificial intelligence is going to be widely used by corporates for the creation of the IP and as well
True.
as management of the IP. As you mentioned,
Hmm.
I'm
Hmm.
quite sure that this is a very elaborated discussion, and all the viewers and the audience out there are going to get benefit. I want you to continue, Saransh.
Thank you so much. So, traditionally, I was speaking about the traditional notion, as the question suggests. So, traditionally, we were focused on intellectual property creation and protection. The simple one was that. But now, through the use of artificial intelligence models, you, as an IP owner, is not able to understand where my IP infringement is occurring. This question also says about copyright, trademark, and patents, right? In copyright, the major issue is there. What you are having us literally work, and you, through your literary work, don't know that that other person, the party B, is using your tune. They're using your, what we say, rag. They're using your rag and using your tune to copy it and to make another work. The point is, you know that it is being plagiarized, but you are not able to prove, because artificial intelligence models are so efficient that they are using your model, they are using your instances, and they are using your work, but you are not able to prove because you don't have any clue about the same. But you know in your mindset that this tune has been copied from my side, right? So that's why it is not only challenging, but I think that the IP protection part is becoming very difficult. Let's say, for example, trademark. In trademark, let's say if you are trying to the brand recognition part, right? Artificial intelligence is creating their own brand, and artificial intelligence is not only creating their own brand but destroying others as well, right? So here there is a lot of debate when it comes to the big corporates, the small corporates, the big corporates who are having access of to artificial intelligence models, the big one, right? And the small corporates don't have. So small corporates are getting smaller and smaller, and big corporates are getting more huge because of the use of artificial intelligence models in such an efficient manner that they are not only creating IP, but they are destroying other IP as well. So
Right.
the
So
traditional protect,
here
yeah.
I'm just trying to kind of connect the dots, like the hindrance part especially. So the
Hmm.
AI itself is kind of reason for creating hindrances. to the
True,
society as well as multiple
true,
parts of the community or the society, like you
true,
mentioned.
true, true,
AI still has that ability to generate some kind of work.
true.
So that is
Mhm.
something that we have been amused of in the past few days, a few years, basically, when it got introduced. At the same point in time, we are now understanding the hindrance that it can cause to some portion of the society or some part of the communities. So I am in a fundamental dilemma right now, Saransh. So can AI generated works be eligible for the copyright protection, and how do we attribute the authorship in such cases?
All right. So, a blunt answer to this is a no. And that answer comes from nowhere but our bare act. In Section 2, Clause D of the Copyright Act, it has specifically mentioned the word person. I think last to last year, I wrote an article on this word only, person, the interpretation of person, right? So when we talk about the attribution of authorship, the Bare Act is very clear with regards to mentioning the word person in the Bare Act, right? Section 2, Clause D. But as we all know, law is open to interpretation. So how this person can be interpreted in a larger scale to also include artificial intelligence model is something which is still in debate and still in the state of developing. What is happening there? In section 2 clause D, it is specifically mentioned that if the literally dramatic or the musical work is computer generated, the person who takes the work, who creates the particular work, or who helps in generation of that work will be the author, right? So let's talk about the mindset of the people who have written the Bare Act. When they wrote the Bare Act, they were focused on the part that the computer work was merely assistive in nature, right? But now it is not merely assistive, it's creating its own. And here the difficulty comes, Siraj. So the attribution part of this authorship is definitely a no. The answer to this is no. But the human involvement is close to none. And I will just give two cases to make you understand more. The case of I was remembering this case, the case of Raghav. The Raghav was a recent case where this Raghav is primarily an AI tool. The AI, this person, I don't remember exactly the name of the petitioner. He filed the copyright in the IP this Indian Copyright Office. The copyright rejected it because why it rejected? The reason was the author is the AI, right? Now what happened? Then the petitioner included his name and make the AI as a co-author. Now there are two authors. First, he himself as an author, as a natural person, and second, the AI model. Right now, the Copyright Office granted registration. But after that, I don't know what happened. But after that, Copyright Office issued a withdrawal notice. But till date, I don't know the exact development. But till date, if you find the exact status of this case, it is granted. The copyright is being granted, but still a withdrawal notice is there to which the no reply has been filed to till date. Now, this is the case where the author was a natural person, right? The same case happened in USA in the Thaler case. The Thaler was also the Thaler was a Stephen Thaler was a natural person. He filed in the US Copyright Office. What he filed? The artificial intelligence made graphics, and then the US Copyright Office is politely said no to the copyright registration because of the very fact that the author was not artificial, the author was not a natural person, it was an artificial intelligence model, right? So we are more of a clear till date that if you are attributing as to what the authorship of the copyright work is, we are clear that the person, or rather a natural person, can be an author and not a person when it comes to artificial intelligence model, as per the law and as per the interpretation is concerned.
Sir, quite nicely explained about the authorship aspect of such generated cases through the artificial intelligence. And thanks for bringing the the cases about the Raghav as well as the other instances in the US where the copyrights have been kind of probably not admitted, or probably there is a dilemma whether to allow or not, and multiple considerations whether if a co-author as a co-author, if you're coming up, maybe the authority is kind of considering, but still there is a dilemma. Let's kind of
But
elaborate.
just one point.
Yeah.
Just one point. I also want to say this Raghav case also filed the copyright in USA and it got rejected. But in
Okay.
India and the USA also Raghav filed as a co-author, right? So one was natural person and one was AI. US Copyright Office rejected it because they don't want any artificial intelligence model to be claimed as an author.
Right, sir. Right, sir. It's a kind of stand by the authority. That is something that will be varying across the geographies. That is something that we have to understand. And I want to get this elaborated on understanding the legal considerations, especially surrounding the ownership of AI generated inventions and innovations. Right now, we spoke about the authorship, and many other inventions and innovations can be done through the AI by the generative AI, specifically if I term it.
Yes.
So what are the legal considerations surrounding this?
Sir, when we talk about legal considerations, specifically focusing on patents, the story is not different from copyright. Still, and I have a strong legal case behind that as well. We have this case of Dabus. Dabus is a very, very famous case where the same person, Stephen L. Thaler, only filed a patent application claiming a Dabus is an artificial intelligence model, right? He filed a patent application in USA, in UK, and I think in Germany as well. But specifically talking about USA and UK, both the country rejected patent application because of the fact that the author cannot be, sorry, the inventor cannot be a natural AI model. So I think the legal consideration, considering the part of patent as well as considering the part of copyright, is no such different part. Again, the same issues of the part of artificial intelligence models as an author will come into picture, and again the patent office and the copyright office will reject it, right? Here there is a catch. What catch? In UK also gives a primary right, or rather I can say moral right, to the person as well. So here UK is open to interpretation, but still I don't find a strong interpretation or a strong case law in UK which I can put here as a part of a jurisprudence. But UK is primarily open to moral rights, primarily open to something which we can say beyond person, right? Moral rights beyond person. So morally you can interpret something, but US is very clear. Fine, you are not going to get any inventorship or rather any patent if the author or if the inventor is an AI model, right? If we talk about India, like say for example, Raghav case is something which create not only a dilemma but created a strong debate as well in the copyright regime and the copyright circle in India, is because how an author, even if co-author is an artificial intelligence model, right? Ultimately, yes, I don't know why Copyright Office gave a withdrawal notice afterwards. I don't know whether they realized their mistake or not, but it's the part of the picture. So this is, I think I'm making it clear that USA and UK are more of a very strict part in when it comes to creating a strong artificial intelligence model as an author. But in UK, there are chances of interpretation, and in India, the picture is very clear about having an author as a natural person.
So the long story short is that the person being a natural person or not is the first consideration that
True,
the
true,
authorities are actually looking
true,
forward, and
true.
maybe a lot of statute would be surrounding that. And
Okay.
apart from that, sir, I also want to understand a bit of AI technologies, how these AI technologies are going to impact the process of the patenting and the trademarking intellectual property.
True. Sir, this was my first introductory remark. As I when I was speaking with regards to heartbreak, and hatred, and a soft corner. So the answer to this is both. The artificial intelligence is not only helping in creation of the intellectual property in such a tremendous manner, but it is also creating a lot of hindrances when it comes to the part of artificial intelligence, or rather artificial intelligence induced IP infringement. So this artificial intelligence induced IP infringement. So these AI models, which all the big corporates are using, they are using it for the IP creation. All the big pharmaceutical companies, all the big pharmaceuticals, not only pharmaceuticals, but all the big, I can say, different industries as well, are using AI models to create intellectual property. And I think, uh, if I'm not wrong, the patents and intellectual property filing, not only in India, but in the world, has increased. And the increase, why it has been increased, the major part and the major help is being done through the efficiency of these AI models, right? So I think this answer to this question is very clear, that AI is definitely inducing and helping the intellectual property creation to such a tremendous level. See this, the influx of 5G, see the influx of 4G, and see the influx of 3G. The base of influx of 5G was tremendous, and it is because of the AI models being used in such a tremendous manner, right? But again, I will say that there is always a bad part, or rather, there is always a hatred that these artificial intelligence models are also inducing and also creating IP infringement and IP interests.
Right, Saran sir. So let us take a last question probably before we conclude the part one of our discussion. I want you to give some specific legal frameworks or regulations in place to address the IP issues arising from the AI advancements, and subsequently to give an understanding that we are going to delve deeper into the concepts of the algorithms of the AI, and much more concepts that we have actually broken into the second episode. Before that, let's try to understand from you the regulations in place to address the IP issues arising from the AI advancements, Saransh.
I always find myself in a very in a position where I'm not able to answer this question, because it's a part of current affairs. Mr. Som Prakash, he is the Union Commerce Minister of State, and in a written reply to Rajya Sabha in February 2024, this one, in a written reply to Rajya Sabha, he specifically mentioned what, that IP, the IPR legal framework, the present legal framework is sufficient to handle the AI-induced work, and that is something which I'm not saying, which is which is a written reply in the Rajya Sabha. So, if you are saying that the specific legal framework when it comes to AI-induced work, there are none. And that was the same question being put forward to Mr. Som Prakash, and he specifically mentioned that there are no such legal framework required. See, whatever we have dealt in the previous questions, what is important and what can be inferred? The inference is there is a strict requirement of a intellectual property regime where the artificial intelligence part has to be addressed. The dilemma is there. But a Commerce Minister of State is stating this in a written reply to Rajya Sabha. So I think I might not be able to answer more beyond that.
Okay, and I think we still have an elaborative discussion pending, so probably we will try to see if this can be getting addressed in the further conversation, Saran. So,
Yes.
viewers, that's about today's episode of StarTalks with Advocate Saransh Chaturvedi, which brings a lot of insights on legal framework of artificial intelligence and the intellectual property. We would also be covering more topics on implications of AI algorithms and new age trends in the intellectual property law with Advocate Saransh Chaturvedi. Stay connected for the episode. Thank you.